Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. The last podcast before this year's AILA National Conference in Orlando. Gonna be a time. And I'd be remiss, and possibly in violation of my non-existent employment contract, not to mention that Immigrants List will be hosting a lunch on Friday of the conference, where the awardees and speakers will be Illinois Governor J.B. Pritzker, U.S. Representative Hillary Schulten, M-Gage USA, the Family Action Network Movement, or FAM, and the Florida Immigrant Coalition. Politico reports that Governor Pritzker is heading to, quote, DeSantis's home turf, end quote, and notes how in the past, Governor Pritzker's speeches have accused Governor DeSantis of, quote, trying to pass off his covert racism, homophobia, and misogyny as a more reasonable form of Trump republicanism, end quote. Quoting Politico. Won't want to miss the presentation and speech. Lunch included, I believe, albeit with a reasonable donation to Immigrants List. See you there. All the more important as late Friday evening, the Fifth Circuit reversed a district court and sent back a case that may force the Biden administration to spend nearly $3 billion to build a wall on the southern border. 8 cases to discuss. Let's go. Our first case, Dubin v. United States, published by the U.S. Supreme Court on June 12, 2023. This case is not an immigration case at all, but it's the Supreme Court. And Ira Kurzban told me that I should read it and do it on the podcast. And when Ira Kurzban tells you to do something, you sometimes do it. It's a criminal case by a unanimous court with Justice Gorsuch concurring in judgment. It's a healthcare fraud case. Essentially, Mr. Dubin overbilled Medicaid for psychological testing and committed Medicaid fraud in doing so. The way Mr. Dubin overbilled is that he claimed that the testing was done by a licensed psychologist, when in fact it was only a licensed psychological associate doing the testing, which if Medicaid had known, would have reimbursed at a lower rate. It's worth knowing about this decision because the decision is also about whether the conduct additionally equated to, quote, aggravated identity theft, end quote, which under the statutory scheme at issue would then trigger a mandatory 2-year prison sentence. The Supreme Court said that this conduct did not. It was not aggravated identity theft as well as Medicaid fraud. Not so important to immigration why they said it. Instead, it's worth noting how they said it, as the BIA has oft had occasion to find fraud-type crimes and identity theft to be CIMTs. In this decision, it's really the Supreme Court saying that the conduct is not so bad. To the Supreme Court, per the title of the criminal offense, the statute applies only to, quote, aggravated identity theft, end quote. This is a narrowing phrase. Only identity theft is covered, not, say, overbilling ancillary to identity theft. And I seem to recall quite a few narrowing removal statutory titles in the INA. Specific to this case is one example that hits home to some of you. Quote, if a lawyer rounds up her hours from 2.9 to 3 and bills her client using his name, the name itself is not specifically a source of fraud. It only plays an ancillary role in the billing process, end quote. So that's not aggravated identity theft, even if it might be another crime. The title of the statute also applies to only aggravated conduct. I seem to recall an immigration title that similarly only defines aggravated offenses. According to the Supreme Court, a quote, aggravated offense is one made worse or more serious by circumstances such as violence, the presence of a deadly weapon, or the intent to commit another crime, end quote. There's a crimmigration quote I could hang on my wall. Quote, this suggests that Congress had in mind a particularly serious form of identity theft, not simply everyday offenses, end quote. Indeed. Perhaps most important to immigration practitioners challenging the removal consequences of similar state statutes, quote, identity theft encompasses when a defendant uses the information to deceive others, end quote. Restated, a quote, defendant uses the means of identification itself to defraud or deceive, end quote. So if your state identity theft adjacent statute of conviction criminalizes more than that, you've got an argument that it is not generic identity theft, and perhaps not a crime involving moral turpitude. Restated yet again, quote, use of the means of identification must, therefore, be at the locus of the criminal undertaking, rather than merely passive, passing, or ancillary in a crime, end quote. That's what aggravated identity theft is to the Supreme Court. Following many more pages of statutory interpretation, the court ruled for Mr. Dubin. Again, still criminal, just not aggravatingly so. To hold otherwise would simply reach too much conduct to the court. Another arrow in your quiver when arguing for a narrow interpretation of a generic criminal type phrase. Quote, time and again, this court has prudently avoided reading incongruous breath into opaque language in criminal statutes, end quote. What a sentence, Justice Sotomayor. Mr. Dubin didn't use the patient's means of identification in relation to a predicate offense. It's not aggravated identity theft. 2 years in prison avoided. Here's a bit from Ira Kurzban and the concurrence. Ira believes that while the context is of course different, this decision may yet have relevance for immigration, where, for example, someone is charged with re-entry after removal and has on him or her a social security card. The mere possession of another's identity would seem ancillary to the conviction or action of illegal entry in those circumstances, and so, reasons Ira, wouldn't necessarily fall within the scope of fraudulent or deceitful conduct that the Supreme Court believes criminal. More context surely abound. Justice Gorsuch, for his part, concurred in an opinion that I did not read fully, but which starts with, quote, whoever among you is not an aggravated identity thief, let him cast the first stone. The United States came to this court with a view of the statute that would affix the unfortunate label on almost every adult American. Every bill splitter who has overcharged a friend using a mobile payment service like Venmo. Every contractor who has rounded up his billed time by even a few minutes. Every college hopeful who has overstated his involvement in the high school glee club. All of those individuals, the United States says, engage in conduct that can invite a mandatory 2-year stint in federal prison, end quote. Justice Gorsuch, of course, does not believe that should be the case. I'm here for it, Justice. Dare I steal from my Gen Z sister-in-law and say that we are in our decriminalization era? And that is Dubin v. United States. Next up is Odei v. Garland, published by the First Circuit on June 15th, 2023. This case is about asylum. And actually, it starts off by explaining that, quote, this case has its roots in a land grab that occurred long ago and far away, end quote. Ghana, 1984, to be exact. Mr. Odei entered the United States as a visitor in 2001 and overstayed the time authorized by his visa. He later married a U.S. citizen and tried to adjust to LPR status, but USCIS didn't believe that it was a bona fide marriage. Adjustment denied, removal proceedings begun. And eventually he divorced. Mr. Odei married someone else, and she filed another I-130 petition, but USCIS denied that too. Unable to adjust to lawful permanent resident status for reasons likely related to INA Section 204C, Mr. Odei sought asylum and related relief in immigration court. As the basis, Mr. Odei explains that in 1984, the local village chieftain in Ghana stole his family's cocoa farm. When his parents and brothers protested and refused to leave the farm, the chieftain had them beaten. The family fled to the capital of Accra, where they lived for 15 years. Then Mr. Odei traveled to the United States. Quote, he claims that if returned to Ghana, he would be tortured and killed because his family never surrendered formal title to the land that was taken from them, end quote. The immigration judge denied for a few reasons, but the BIA's denial rested on a finding that Mr. Odei failed to, quote, establish a causal connection between the chieftain's predations and a statutorily protected ground, end quote. A no nexus finding. It looks like it's all happening in the withholding of removal context, not asylum, because that asylum application would appear to be many years past the 1-year filing deadline. The First Circuit affirmed the BIA, and to quote the First Circuit in full and really dealing with two withholding of removal elements at once, quote, the BIA decision is not contrary to the petitioner's contention that the chieftain acted on behalf of the government. The BIA simply stated that reprisals perpetrated by government actors based on personal animosities are insufficient to establish a causal connection between the alleged harm and a protected ground. That statement is correct, end quote. The First Circuit also rejected Mr. Odei's argument that his inability to return to his family's farm would itself so infringe on his freedom that he's due withholding of removal. I like the argument, because after all, the withholding of removal statute prevents removal to a country where the non-citizen's, quote, life or freedom would be threatened, end quote. I like it. But the First Circuit wasn't buying it. That is, that mere failure to get your farm back infringes on your freedom, and so is an alternative way to get withholding of removal. And it seems that Mr. Odei may not have developed this somewhat unique view of withholding of removal with case law or authority. But you can. Deeming other arguments waived and the BIA's decision not crazy, the First Circuit affirmed the removal order. And that is Odei v. Garland. Next up, two from the Fifth Circuit. First, Alexandre-Matias v. Garland, published by the Fifth on June 13, 2023. This decision is about in absentia motions to reopen. And it's a short one. Many of the other ones that are not from the Supreme Court or the Second Circuit are this week. As best can be deciphered, Mr. Alexandre-Matias did not appear for his removal hearing in 2005, was ordered to remove in absentia, and moved to reopen that order in 2018 after the Supreme Court's Pereira decision. The Fifth Circuit rejected many an argument without really explaining them, or what happened below. But of interest, it seems that the record didn't actually show whether DHS had ever even filed the notice to appear with the Immigration Court in 2005. Seems like kind of a big deal. But the Fifth Circuit deemed even that argument a claims processing rule argument. That is, that even filing the NTA with a court is a claims processing rule and not jurisdictional, and so is a claims processing rule violation maybe if it doesn't happen. As such, as filing the NTA is not a jurisdictional type action, the fact that Mr. Alexandre-Matias only brought up the argument for the first time before the Fifth Circuit means that he waived it. Strange stuff. I mean, procedurally it makes sense. Jurisdictional arguments can't be waived, so if it was jurisdictional, maybe the Fifth Circuit could hear the argument for the first time on petition for review. It just seems a bit strange that actually filing an NTA is not jurisdictional and is instead a claims processing rule that can be waived. Nor was the Fifth Circuit concerned by the fact that without a notice to appear, the IG appears to have possibly relied on simply a Form I-213 ICE police report to sustain removability and conduct the entire removal proceedings. After all, explained the Fifth Circuit, I-213s are, quote, inherently reliable, end quote. Strange stuff. But then again, the fact that these arguments are being made for the first time before the Fifth Circuit and weren't apparently brought before the IJ or the BIA might explain why the Fifth Circuit is giving them short shrift. Turning then to the regular insufficient notice arguments that the Fifth Circuit is so often adjudicating under similar fact patterns. Because after all, the NTA, actually filed with an immigration court or not, was deficient. Well, the Fifth Circuit returned to the I-213 again, reasoning that the I-213, quote, references the time, date, and location of the scheduled removal hearing, and records that Mr. Alexandre-Matias was provided with the necessary forms to effect the NTA, as well as a certified interpreter to translate the NTA paperwork, end quote. For the life of me, I do not understand how an I-213 can possibly stand in for an NTA, or how any of this complies with Rodriguez, the INA, or the law. The Fifth Circuit does not cite to authority for what it seems to be holding. But here it is. The Fifth Circuit then summarily rejected Mr. Alexandre-Matias' due process argument and denied the petition for review. I don't know. One could be forgiven by coming away from this decision thinking that this Fifth Circuit panel just doesn't like these type of cases. And that is Alexandre-Matias v. Garland. Next is Medina Carreon v. Garland, published by the Fifth Circuit on June 15th, 2023. A little more meat on this one. This case is about non-LPR cancellation of removal. Kind of. Mr. Medina Carreon is from Mexico and has lived in the United States since entering without authorization in 1996. But in 2011, he was convicted of offenses that arose out of an illegal cockfighting ring, after which DHS placed him in removal proceedings. According to Mr. Medina Carreon, cockfighting is common in Mexico and he didn't know it was illegal in Texas where the offense occurred. Nevertheless, he was convicted, and in removal proceedings he applied for non-LPR cancellation of removal, as he had been here for over 10 years and claimed that his removal would cause extreme and exceptionally unusual hardship to what appears to be his U.S. citizen spouse. The immigration judge, however, denied based on a bit of a preliminary finding. Non-LPR cancellation of removal requires that the applicant establish good moral character during the 10 years immediately preceding the application. INA Section 101F defines what isn't good moral character, but then has a catch-all provision that essentially says that an immigration judge can find that a non-citizen lacks good moral character for reasons not listed in the statute. The immigration judge determined that the cockfighting meant that Mr. Medina Carreon lacked good moral character. Plus, the IJ reasoned he had hired individuals to work without authorization and he had paid them cash. And on one occasion, at least, he had driven on a suspended license. The BIA affirmed, and the Fifth Circuit dismissed the petition for review. First was a procedural argument. Mr. Medina Carreon alleged that the BIA erred by allowing 2 temporary board members whose temporary terms had expired to sign the affirmance of the removal order. Mr. Medina Carreon argued that this made the BIA's decision, quote, ultra vires, end quote. Mr. Medina Carreon didn't file a motion to reconsider with the BIA to make this argument, but he doesn't need to anymore after Santos-Zachariah from the Supreme Court a few weeks ago. The Fifth Circuit just didn't agree with the substance of the argument. 8 C.F.R. Section 1003.1 A4 permits the appointment of temporary BIA members for 6-month stints. Historically, in my experience, they've remained for much longer than that. And a quote, agency acts ultra vires when it goes beyond what Congress has permitted it to do, end quote. So if the Fifth Circuit agreed with the argument, it would probably need to vacate the removal order. Mr. Medina Carreon argued that EOIR's, quote, director lacked authority to renew the members' terms beyond the initial 6-month period, end quote. But to the Fifth Circuit, it was actually the Attorney General of the United States who had reappointed these BIA members. And the paperwork was done correctly, reasoned the Fifth Circuit. Oil submitted that paperwork for the first time on petition for review, and the Fifth Circuit considered it. Not gonna lie though, if it had been EOIR's director, and not the Attorney General, who appointed those temporary BIA members past their 6-month terms, it seems that Mr. Medina Carreon's argument would have gotten farther, and might have even won the day. Hard to develop it, though, when the paperwork is submitted for the first time on petition for review. Turning then to the substance of the cancellation of removal denial, the good moral character stuff. Here, Mr. Medina Carreon ran into the jurisdiction stripping provisions and the Patel decision from the Supreme Court, which the Fifth Circuit now reads as barring review of an agency finding that the non-citizen lacks good moral character. That is a factual finding, reasoned to the Fifth Circuit. Mr. Medina Carreon's argument that the IJ and the BIA misweighed evidence or ignored favorable factors wasn't sufficiently legal enough to get over Patel. Mr. Medina Carreon had more arguments, though. He was coming at the BIA from all sides. Looks like the IJ and the BIA relied upon matter of Castillo Perez from 2019 to deny relief in this case. And while the decision doesn't say why, if I recall the decision, the IJ and the BIA may have relied upon Castillo Perez to hold that criminal activity should be weighed heavily in a discretionary analysis. Who knows? But it's probably what the IJ and the BIA did. Here's the thing, though. Castillo Perez was actually ultimately issued by one of the number of Trump administration temporary attorneys general. I want to say Whitaker. And so Mr. Medina Carreon argued that the decision itself and reliance thereupon, quote, was issued without legal authority due to alleged defects in the acting attorney general's appointment, end quote. Go on. The Fifth Circuit would not, because Mr. Medina Carreon, quote, failed to brief the issue adequately, end quote. Ah, shucks. But yeah, check out Casa de Maryland Incorporated v. Wolf, 486 Fed Sup 3D 928 out of the District of Maryland in 2020, for the detailed explanation of why Acting Attorney General Whitaker's time as temporary Attorney General may not have complied with the law and might taint everything he touched, including immigration decisions. Finally then, the merits. The Fifth Circuit disagreed with Mr. Medina Carreon's argument that the cockfighting wasn't so bad as to warrant denial as a matter of discretion and good moral character. Plus, there is a BIA decision finding cockfighting to be a crime involving moral turpitude. Not relied upon here, but it's out there. Finding nothing wrong with the agency's denial of voluntary departure either, the Fifth Circuit dismissed and denied the petition for review. Interesting arguments, though. And that is Medina Carreon v. Garland. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey, and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. This podcast is also sponsored by Capital Good Fund. Millions of families seeking to improve their immigration status face financial barriers due to the high cost of legal services. Nonprofit Capital Good Fund is working to make these resources available to all, especially those who would otherwise not qualify for traditional loans. Certified CDFI Capital Good Fund is partnering with attorneys to provide the financial services families need. They offer affordable financing with no closing fee or down payments for those working with attorneys to move their case forward and get attorneys out of the accounts receivable business. To learn more about the program, email immigration@goodfund.us or call 866-584-3651 and tell them who sent you. Next up is Medley v. Garland, published by the Second Circuit on June 15th, 2023. Hope you enjoyed that break, because we're diving into due process and the legality of an immigration arrest. ICE alleged in its Form I-213 submitted in removal proceedings that Mr. Medley is from Jamaica. He overstayed his visitor visa in 2006 and he was arrested by ICE in December of 2017. Now I'm not going to lie. Sometimes you can't pick your cases, and some non-citizens aren't always the best vehicles to move the law forward. Quote, from 2009 to 2017, Mr. Medley was arrested 32 times and charged with, inter alia, assault, attempted assault, resisting arrest, strangulation, endangering the welfare of a child, burglary, criminal mischief, domestic violence, menacing, criminal possession of a weapon, harassment, and unlawful possession of marijuana. End quote. Like that we now have to qualify the possession of marijuana, though, in New York. Anyway, not all of this criminal Medley resulted in convictions, but 9 did. DHS initiated removal proceedings. Again, the December 20th, 2017 ICE arrest, which is so important to this decision. 3 ICE officers approached and arrested Mr. Medley inside a 7-Eleven in New York City. He was with his wife and 3-week-old daughter. He had just left the hospital following a recent hand surgery and intended to return to the hospital that same day. Mr. Medley testified that he asked ICE to be careful with his hand, but that instead they, quote, ignored his entreaties and pushed him against a display rack, causing his hand to begin bleeding through the bandage as they handcuffed him, end quote. They took his medications and ignored his plea to be taken back to the hospital. They found a Know Your Rights card in his possession given to him by his immigration attorney and threw it to the ground. Mr. Medley also alleged that the ICE officers didn't identify themselves as ICE officers until he was placed in the ICE car. That's Mr. Medley's story. DHS countered in its I-213 that Mr. Medley was, quote, arrested without incident, end quote. At the detention center, Mr. Medley alleged, ICE refused to call his lawyer and kept questioning him. He said he was refused food and water, only, quote, after his lawyer sent a message to the facility invoking Mr. Medley's rights did the officers stop questioning him, end quote. Eventually, Mr. Medley was moved to another facility and received treatment for his hand. Now, Mr. Medley the human is removable because he overstayed his visa. He doesn't need to testify in court, and DHS has the burden to establish alienage, that is, that Mr. Medley isn't a U.S. citizen or national. We know from last week that he's not a national because he's not from American Samoa. Had to throw that in. But if ICE can't prove who Mr. Medley is, how can they establish alienage? And if they don't have his birth certificate from Jamaica or other documents, it might actually be an issue. That is, unless they can use his statement from his arrest that he was indeed Mr. Medley. And maybe some of the other things he said too. In the criminal law context, if an arrest violates the Constitution, police can't use statements or evidence related to it. Fruit of the poisonous tree, they call it. We immigration attorneys have one sentence from a 1984 Supreme Court decision that would appear to incorporate this framework somewhat into immigration law so long as the constitutional violation was egregious. And of course, circuit decisions flesh that out. Alleging the arrest unconstitutional and violative of the regulations, Mr. Medley moved to terminate his removal proceedings multiple times. Also, the notice to appear was deficient, of course. Problem is that before that, Mr. Medley, with the assistance of an attorney, conceded removability and applied for immigration relief. So that's, in many contexts, not the best strategic decision if you're going to then move to terminate removal proceedings. Everything was denied and it's procedurally complicated, but it's mainly the due process violation motion to terminate that is now before the Second Circuit. Let's get the deficient NTA motion to terminate out of the way, though. Mr. Medley's proceedings have been going on for a long time, including when we were all arguing that deficient notices to appear were jurisdictional rather than claims processing rule violations, as we've now all learned. As such, the Second Circuit rejected Mr. Medley's universally foreclosed argument that the immigration judge lacked jurisdiction over his case. Claims processing rule not discussed. Next time. Again, the case is really about the alleged constitutional violations. In this case, because Mr. Medley was initially admitted into the United States, ICE is bringing removal charges under Section 237 of the INA, and that means that ICE must not only establish alienage, as it always must, but it must establish his removability by clear and convincing evidence. That is, that he overstayed his visa and never adjusted to LPR status. And uniquely for these type of cases, Mr. Medley is not arguing that the immigration judge needed to suppress evidence of his alienage or removability. That is, that the immigration judge needed to suppress the Form I-213. And that's because, in the Second Circuit at least, where there exists an egregious constitutional violation or even, quote, significant regulatory violations that occurred during the arrest or interrogation phases of removal proceedings, end quote, the Second Circuit has gone beyond mere suppression of evidence. In such cases, it, and immigration judges sitting in that circuit, might order one of the three following things. 1. Invalidation of the removal order with prejudice. 2. Suppression of all evidence obtained during the registration and interrogation phases. Or 3. Terminating the removal proceedings without prejudice. Mr. Medley wants proceedings terminated in their entirety because of what happened, regardless of whether DHS can establish removability, which again he conceded anyway. Swinging for the fences. And good to know that that's an option in the Second Circuit, with prejudice to boot. Yes, in the Second Circuit, quote, pre-hearing violations that were so egregious as to shock the conscience would call for invalidation of the removal orders with prejudice, end quote. That is not nothing, nor is it the law of all circuits, I believe. The Second Circuit just didn't see that standard met here. For example, it's likely the case that to qualify, quote, the challenged conduct must not only be wrong, it must be extremely so, truly brutal and offensive to human dignity, end quote. There's no one-size-fits-all standard. The Second Circuit, for example, has indicated that conduct is so egregious where a stop or an incident is based entirely on race. Again, though, it's a case-by-case analysis. Here, Mr. Medley alleged that the officers violated the regulations by using excessive force during the stop. That's 8 C.F.R. section 287.8, 81II and III. He also alleged that then, they violated the regulations by not letting him call his attorney. Then ICE allegedly deprived him of food, water, and medical care, coercing him to make statements. That allegedly violated the regulations protecting his right to counsel, 8 CFR section 292.5b, and his right to remain free of coercion, 8 CFR section 287.8 C2 VII. Mr. Medley actually made a whole bunch of other regulatory arguments too, that simply didn't make it to circuit court. Check out footnote 4, though, if you're looking for a guide of regulatory violations that you can claim in similar circumstances. Even assuming all the allegations true, though, the Second Circuit didn't see them as sufficiently egregious to require termination, with or without prejudice. There was no allegation that all of this happened because of Mr. Medley's race, for example. And in other cases, the Second Circuit seems to have sanctioned some force in arresting individuals and some delay in their speaking to attorneys. Particularly given Mr. Medley's apparent documented history of encounters with police, what the ICE officers did here was not sufficiently egregious. It's a bit blurred based on how the Second Circuit is construing the specific violations before it, but there you go. Quote, unpleasant interrogation that does not rise beyond the level of being long and tiresome, end quote, does not cut it. Sounds like a standard to me, though. Nor was Mr. Medley subjected to marathon questioning, or was he misinformed about his rights. Might qualified if he had been, though. Plus, quote, he concedes that he received medical attention soon after the interrogation ended, end quote. Nor does any of this separately violate Mr. Medley's constitutional due process rights, given the, quote, brevity of the threats of withholding food, water, and medical treatment, and the low level of his need for medical treatment, end quote. If I'm being honest, it seems like the type of physical wound Mr. Medley had on his hand, a recent wart removal, may have played a part in how the Second Circuit was viewing the severity of the situation. Quote, minor injuries in the process of an arrest do not necessarily justify an excessive force claim, let alone shock the conscience, end quote. Mr. Medley, therefore, will not get his case terminated. Seems like a bit of a close one to me, though, and certainly hard fought. Before we move on, this case seems important, especially in the Second Circuit. Although Mr. Medley didn't win, the decision clearly outlines a framework beyond mere Barcenas hearings and beyond mere exclusion and suppression of evidence. This case clearly stands for the proposition that, under the right circumstances, even where DHS can meet its burden to establish removability, And even where a non-citizen concedes removability, removal proceedings must be terminated, and a non-citizen cannot be removed from the United States. Indeed, the Second Circuit assumed without deciding, for example, that, quote, the use of excessive force, if egregious, can be the basis for terminating proceedings with prejudice, end quote. And of course, the Second Circuit goes into a pretty big discussion on the issue when a sufficiently race-based allegation is made. A decision worth remembering. And that is Medley v. Garland. Finishing the episode with 3 Eighth Circuit decisions in a row. First, King v. Garland, published by the Eighth Circuit on June 14th, 2023. This is a very short case about healthcare fraud. And what the heck are the chances? Federal aggravated identity theft. Miss King is a lawful permanent resident from Sierra Leone who did those things. DHS alleged that it all equated to an aggravated felony under INA Section 11843MI, and so that Miss King was removable. DHS also alleged that at least one of the convictions, of which there were multiple, equated to a crime involving moral turpitude committed within 5 years of Miss King receiving LPR status. Miss King conceded removability, so we don't get to talk about that Supreme Court decision, and sought, it seems, to readjust to LPR status with an INA Section 212H waiver of her inadmissibility. The decision is less than clear, but that seems to be what's going on. Unmentioned in this decision, but historically, and under the statute, an aggravated felony will bar receipt of a Section 212H waiver. But nearly all the circuits, and now the Board of Immigration Appeals, read the very oddly worded aggravated felony bar to 212H relief only to apply, essentially, if the LPR entered the United States as an LPR, not if they adjusted to LPR status within the United States and were then convicted of an aggravated felony. So that must be what happened to Miss King. Decision doesn't say. But she did apply for the waiver, and the IJ did decide it, so that must be what happened. And if a 212H waiver is granted in conjunction with an application to readjust to LPR status, it'll waive Miss King's CIMT inadmissibility. But like all waivers, Section 212H is discretionary. The immigration judge held that Miss King didn't warrant it. The BIA affirmed. And that is where Miss King has a big problem, because after Patel, certainly circuits are barred from reviewing a discretionary denial of a Section 212H waiver. Miss King did her best to turn her challenge into a legal one, for example, that the IJ and the BIA ignored favorable factors, such as her family ties in the United States. But the Eighth Circuit believed those factors considered by the agency. Nor could the Eighth Circuit, the court reasoned, even review whether the agency overly weighed Miss King's criminal history. Again, the jurisdiction-stripping provisions and Patel. Which meant that Miss King lost and will presumably be removed to Sierra Leone. 4-page decision. And that is King v. Garland. Next up, Zongo v. Garland, published by the Eighth Circuit on June 16th, 2023. This case is about asylum and credibility. Mr. Zongo is from Côte d'Ivoire, but is a citizen of Burkina Faso, and entered the United States on a student visa in 2016. But he withdrew from university, terminating his student status, and sought asylum based on his political opinions and affiliation with the Congress for Democracy and Progress Party. Quote, 3 years later, he updated his affidavit with 2 additional bases for fear of future persecution, his Christian faith and Fulani ethnicity, end quote. An immigration judge ultimately believed that there were inconsistencies in Mr. Zongo's story, issued an adverse credibility finding, and denied all relief and protection. The BIA affirmed. Before the Eighth Circuit, it mostly came down to differences between Mr. Zongo's 2017 affidavit and 2020 affidavit. Query why asylum seekers are always submitting these multiple affidavits when, to my knowledge, they're not required by the rules to submit any affidavit, and the asylum seeker is going to testify in court anyway. Doesn't really happen in any other area of law, right? Giving the prosecutor a sworn statement under penalty of perjury to then cross-examine your client to, as your client testifies in court under penalty of perjury? Anyway, the initial 2017 affidavit was only 2 pages long. The 2020 affidavit, likely submitted with the assistance of counsel, was 30 pages long. There are apparent discrepancies. Apparently, the 2020 affidavit mentions 4 detentions, while the 2017 affidavit is not specific. The 2020 affidavit mentions detention at a military camp, while the 2017 affidavit only mentions encounters with police. And the 2020 affidavit emphasizes a 2014 Burkina Faso insurrection that resulted in a hospitalization, while the 2017 affidavit doesn't mention any of it. Again, this whole multiple affidavit, or quite frankly any affidavit at all thing, can be prejudicial to asylum seekers in immigration court. In the Eighth Circuit, quote, "The cumulative effect of multiple inconsistencies, even if not directly material to the petition, can support a reasonable fact finder's adverse credibility determination," end quote. Met here. That means that Mr. Zongo can't meet his burden for asylum or withholding of removal. Mr. Zongo, of course, disagreed. But the Eighth Circuit explained that when there are 2 plausible explanations, one an explanation, and the other simply that the non-citizen isn't credible, an immigration judge need not pick the one helpful to the non-citizen. With the adverse credibility finding, that left only Convention Against Torture protection. But see, Mr. Zongo didn't actually argue that before the BIA. That is, that he was eligible for CAT, notwithstanding adverse credibility. So the Eighth Circuit deemed the argument unexhausted and therefore waived. And Mr. Zongo lost his case. And that is Zongo v. Garland. Our final case is Rincon Barbosa v. Garland, published by the 8th Circuit on June 14, 2023. This decision is about the possession of methamphetamine. And who among us hasn't... Alright, I'll stop right there. Mr. Rincon is a lawful permanent resident from Mexico, and he did possess methamphetamine, receiving a conviction for doing so under Kansas Statute Annotated Section 21-5706A in 2018. DHS alleged that made him removable under INA Section 237A2BI because it was a violation of a law relating to a controlled substance. The immigration judge and the BIA agreed. The categorical approach applies. And on the surface level, it would appear satisfied. Both Kansas and the federal government criminalized possession of meth in 2018. But the categorical approach is not so simple. Because see, as the IJ found, although Kansas criminalizes possession of meth, it also criminalizes possession of some substances that the federal government does not, at least not in 2018. That makes the Kansas drug possession statute overbroad, which means that Mr. Rincon isn't removable unless the statute is divisible as to the drug possessed. If divisible, it would then permit an IJ to look at the conviction documents and see that indeed the substance possessed was meth. But if not divisible, the analysis is over. The IJ believed that the substance in Kansas is an element, rather than a means of committing the offense, making the statute divisible. That is, when prosecuting a possession offense, Kansas prosecutors must prove the specific substance possessed. So Mr. Rincon lost before the IJ. Likely aware of the developing and favorable Eighth Circuit precedent on the issue, Mr. Rincon appears to have pivoted on appeal to the BIA. There he argued that Kansas's definition of methamphetamine in 2018 is itself broader than the federal definition of methamphetamine, and that definition is certainly not divisible. If true, Mr. Rincon should win under Eighth Circuit precedent. Similar precedent developing in at least the 11th and 7th Circuits. But the BIA deemed the argument waived, because Mr. Rincon hadn't made it before the immigration judge. And here we are at the Eighth Circuit, where everyone agreed that yes, the Kansas drug possession statute criminalized possessing more drugs than the feds in 2018. But the Eighth Circuit agreed that the Kansas statute was divisible as to the drug possessed. For reasons not used by the BIA, by the way. Oil made different arguments to get to the same result as the BIA. The Eighth Circuit said that was okay, Chenery Doctrine notwithstanding. Because after all, the Kansas Supreme Court said in 2009 that each different drug of the statute is a separate, quote, unit of prosecution, end quote. meaning to the Eighth Circuit that, quote, a person who possesses a package of cocaine and a package of methamphetamine at the same time may be prosecuted for two separate offenses, end quote. Strong argument for divisibility. Although that Kansas Supreme Court decision was adjudicating a slightly different statute, the analysis was, quote, strong evidence, end quote. Using the now familiar double jeopardy type logic for the analysis, the Eighth Circuit concluded that a, quote, defendant cannot be convicted and sentenced for two offenses with identical elements arising from the same facts, end quote. So if he can be convicted for possessing two different controlled substances, it strongly indicates to the Eighth Circuit that the substance possessed is an element, meaning a separate crime, rather than simply a means of committing the same crime. Divisibility. So too, said the Eighth Circuit, the jury instructions read as follows, quote, the defendant is charged with unlawfully possessing, insert name of controlled substance, end quote. And that the prosecution must prove that the defendant, quote, possessed, insert name of controlled substance, end quote. So a jury must make a finding as to the substance possessed to convict in the jury instruction documents. Indicates divisibility. The Eighth Circuit disagreed with Mr. Rincon's alternative reading of those same jury instructions. In fact, Kansas law apparently won't allow marijuana and THC possession to be charged in a single count. So that's some nuanced divisibility. Ah, said Mr. Rincon, but all possessed substances in Kansas have the same punishment. The inverse of a logic employed quite often and recently by the BIA. That would indicate that the possession are means rather than elements, because they all have the same punishment. However, explaining that heads I win, tails you lose, quote, while different punishments would conclusively establish the drug type is an element, equivalent punishments do not show that drug type is a means, end quote. Mr. Rincon, therefore, is removable. But guys, is Kansas's definition of methamphetamine overbroad? What if all of this is for naught, and Mr. Rincon is right that Kansas meth doesn't match the definition of federal meth? Well, as the BIA deemed the argument waived, the Eighth Circuit would not permit a, quote, end run around those discretionary agency procedures, end quote. That is, deeming arguments waived when not made before the IJ. Seems like the BIA and the Eighth Circuit really don't want to grapple with the argument. That might indicate that the argument has legs. Seems like next time, by one of you, the argument very much needs to be made at the immigration judge level. And that is Rincon Barbosa v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.